Good morning, everyone. This is the April 6th, 2022 docket of the Kansas Court of Appeals, and I'm Judge Anthony Powell. I'll be our presiding judge for this morning's case. With me are two very distinguished judges, Judge Henry Green, who is the most senior judge on our court, and also with us is one of our senior judges, retired district court judge Richard Walker is with us, and so I'm pleased to be joining this panel with them. The next case on our docket this morning is the case of State of Kansas versus Brian Robinson, case number 123916. Could the court have the appearances from the appellant, please?
Good morning, Your Honors. My name is Barry Clark, and I am appearing for Mr. Robinson, the appellant.
Thank you very much. And appearances for the appellee.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers.
Thank you very much. I see that we have scheduled 15 minutes each side for argument on this case today. Mr. Clark, would you like to reserve any time for rebuttal?
If I could have 2 minutes, please.
2 minutes is granted. We've read your briefs, and so we are familiar with the case. And Mr. Clark, you may proceed.
Thank you, Judge. I'm gonna be brief. May it please the court, counsel. This case is a case in which we have alleged that the stop of the vehicle was unlawful. Part of the record is a 911 call that was made to the Marion County Sheriff's Department, in which a gentleman describes a vehicle in a small community, Florence, in the middle of the afternoon, behaving in what he describes as an odd fashion. As you'll recall, he said that the occupant was scoping the town, that when he approached it, the vehicle left abruptly, used some descriptive opinion type terms such as he left like a bat out of hell. Also opined that the vehicle was driven faster than most people drive. The caller went on to relate that he talked to another gentleman who related that he talked to a woman who was scared in the process for some reason. There's no particular facts that are set forth in the call as to why this woman would have been scared, but it is about fourth hand. So the officer in his testimony admitted that the 911 call contained no facts, which in his view justified a belief that a crime had been committed. Now, I understand that the standard is not his subjective view, rather it's objective in nature, but I think that when you judges review that video or that audio tape, we think you'll reach the same conclusion. The judge described that activity as odd, and perhaps it was. That may be a good description, but that was the description that Judge Powers gave in the hearing. The deputy testified that he elected to follow this or to try to find this vehicle, which was traveling eastbound on Highway 50, and that he in his cruiser got on Highway 50 and sure enough found the described vehicle traveling 30 miles an hour in a 65 mile per hour zone. I think it's important to note, I crossed the officer about whatever traffic might have been in the area, and he said there was none. There was no other traffic. This slow moving vehicle didn't impede anybody. In fact, the officer testified that the vehicle didn't impede the deputy either. He chose to follow it. I think the only reasonable conclusion is that, as he stated, his stated purpose was to follow the vehicle to investigate this odd described activity. It's important to note that while following the vehicle, he ran the tag on the vehicle, which is clearly an investigative purpose. He didn't observe any erratic behavior. He observed no traffic infractions. The trial court specifically concluded that the officer observed no violations of law. So at the suppression hearing, the judge ultimately concluded that this was an appropriate safety stop. I didn't brief this. I probably should have. But one of the statements made by the court was, I'm going to take judicial notice of the fact that this is a dangerous highway. I don't know that that's an appropriate subject for judicial notice, but that's what the trial court did. It certainly contradicts the condition of the roadway at this particular juncture.
Oh, excuse me, didn't the judge qualify that by saying based on other cases? And the judge was saying, I drive that all the time. And I was saying based on other cases and testimony I've heard, which may or may not have been appropriate, but I think there was a little more to it than what you said.
Yeah, Judge, you may, as I recall, you're from Newton.
Yeah.
You probably driven that stretch. Years ago, there was a lot of highway construction there, and a bunch of trucks, rear-ended vehicles that were stopped at stop signs on stretches of interstate or Highway 50. So I don't know what cases the judge was referring to, but he did make those comments. I think referring to civil lawsuits, as I recall. But that said, it's inconsistent with the condition of the roadway at this juncture when the officer was following the car. There's no other described traffic. So the officer states that he had two reasons for stopping the vehicle. The fact it was driving 30 in a 65, and the allegations in the 911 call that have been made to dispatch. We don't think that either of those bases are legitimate. We don't believe that the mere fact of a vehicle being driven 30 in a 65 with no other traffic in the area is sufficient for the officer to conclude that the driver's in peril. Certainly no one else was in peril. And we don't think that should support a safety stop basis. Moreover, based on the Morales case that I cited in my brief, there's a real danger when we couch investigatory stops under the guise of a safety stop. As the Morales case and the Ellis case and Cade all, not Cade, but the Ellis case and the Morales case and its progeny state, these things need to be separate. Clearly, this stop was made for an investigative nature. You know that because the officer said that's why he made the stop. You know that because he ran the plate before he ever concluded the stop of the vehicle. So he's fishing, and so we think that is prescribed by Morales and Marks and the balance of the other cases that are cited in our brief. I would want to comment just briefly. In my opponent's brief, the states suggest that crimes were described in the 911 call. We respectfully disagree with that. As I recall, counsel stated that perhaps an assault or a terroristic threat or a criminal threat was described. There's simply no evidence of that. There is evidence, third or fourth hand, that a woman claimed to be afraid. There's no explanation as to why she was afraid. Same thing with speeding. To suggest that the caller's statements that this vehicle took off like a bat out of hell, that it drives faster than most people drive, those are opinions. Those are not a reasonable suspicion for a speeding violation. So we think it's devoid of facts for an investigatory stop. I think it's insufficient for a safety stop, and we think they're not divorced from one another as they are required to be. That's what I've got. And if the court has any questions, I'd be happy to entertain them.
I've got a couple of questions, one not serious and one serious. My first is whether Meatloaf should have been called as an expert witness on what a bat out of hell means, but I will skip that. And my serious question is, is it ever possible that, I mean, when I think impeding traffic, you're right. I think of maybe a line of cars backed up and people getting impatient and pulling out and all that. But can a single car ever impede traffic, even if there isn't a backup? I mean, that's what the officer seemed to indicate. Isn't his opinion entitled some credibility?
Well, I think one of the things that I briefed in my my brief was a case that had interpreted KSA 81561, which is, I think, the basis that the court is inquiring about at this point in time. And if you give me one moment, please. 1561 prohibits vehicles from driving at such a slow speed so as to impede traffic, not to potentially impede traffic, but so as to impede traffic. I believe, respectfully, Your Honor, that it needs to, in fact, create an impediment to the flow of traffic. And in the specific case that I cited, the only case I could find interpreting that statute didn't deal with a probable cause or a reasonable suspicion type scenario as this case does. It was a trial, and in that particular case, a combine was stacking up, many cars driving at 12 or 13 or 14 miles an hour on a highway. That's very different from the facts of this case. So I don't think the statute refers to the potential for impeding traffic. My plain reading of the statute, I hope you'll agree, requires that actual impediment must occur.
Thank you. I appreciate your comments.
Any other questions from the panel? All right, seeing none, thank you.
Thank you.
Ms. Chalmers, you have 15 minutes.
The state would stand by the fact that reasonable suspicion here existed for speeding. I think is probably the one we have the best evidence for. Reasonable suspicion is not beyond a reasonable doubt. It's not probable cause. It's just reasonableness. Saying someone is driving like a bat out of hell and faster than normal allows a reasonable person to conclude that the person would have been speeding to permit a traffic stop in this case. And it doesn't matter what the officer, as Mr. Clark pointed out, what the officer subjectively believes. It's an objective officer here. So this court, frankly, can listen to this tape and say, yes, there was reasonable suspicion. I was hoping to actually figure out if Florence, Kansas had a leash law, but I was unable to divine that fact. Because if they had a leash law, we would have a violation for that particular ordinance as well. But here we have, unquestionably, the officer is asking, or is being reasonable. You have a suspicious vehicle, and then you have a suspicious vehicle that is potentially endangering either himself or others. At that point, the officer should be allowed to do a stop. If what the defendant seems to want here is that officers can never investigate suspicious people as long as they're in vehicles, we just can't do that. And we can't stop them if they behave suspiciously. And then there might also be some kind of criminal investigation happening. And I don't think that's reasonable for a multitude of reasons. First of all, I don't think, especially if an officer suspects a DUI, which is usually what is happening when someone is in a vehicle and behaving suspiciously, that there will ever be a context where the officer is not also having an investigative purpose in the back of his or her mind while figuring out if there's a valid traffic stop. This stop did also occur close to the county line. So it was right before the Chase Marion County line. The officer had to make a judgment call here about whether or not he could stop. As to the running of the license, I covered that in my brief. Ellis doesn't say you can't do any investigative purposes. In fact, in Ellis, they took the ID and the court said that was fine. You just can't continue to detain once you do the stop and figure out that there's no need for, or that there's no reasonable suspicion to continue. Here, though, the second this defendant was stopped, the officer had reasonable suspicion and probable cause of a DUI based on the open container. So the only thing we have in this case is, was this stop valid? And I just can't see under the Fourth Amendment how this officer's actions weren't reasonable. Even if this court finds, one, that there was no reasonable suspicion, and two, that this wasn't a valid public safety stop, I don't think this should be suppressed under the good faith, or this should not be suppressed because of the good faith rule. The officer's actions here were not flagrant. They were not a violation of a gross and flagrant violation of any constitutional right. The officer was just trying to make sure that this person was safe to be in a vehicle And I do think that some deference should be given to the district court judge here who said, hey, I've sat over trials. I've watched people die on this highway. 30 on this highway is dangerous for people. And my question is, how is that not reasonable? And it can't just be, I disagree that the interpretation of the statute is, well, they have to have traffic around. If someone's driving 5 miles an hour on a highway, I think an officer is allowed to be like, is everything okay? Because that person is endangering themselves at that point. 30 may or may not be more reasonable, but I think it's a reasonable judgment call that this officer with experience in this area and a judge with experience in this area to conclude that that was a safety issue and needed to be checked up on to make sure that this man who had previously been acting suspiciously was in fact okay. And I do think, as another point, that this case can be distinguished from Morales because we don't have one incident like we did in Morales. In Morales, there was one contact. Here we have the suspicious 911 call, which is a citizen being concerned, and then the officer's own observations of a safety concern. So because of the two contexts, there are two competing concerns. That's just not present in Morales, and the case can be distinguished. For all of the reasons I set forth in my brief, the state would respectfully request that you affirm the conviction in this case.
Thank you, Ms. Chalmers. Any questions from the panel? None. Thank you. Mr. Clark?
Thank you.
Rebuttal.
May it please the court.
Did you reserve 2 or 3 minutes? I suddenly can't remember.
2 minutes, and I won't need it all. Just a comment on the good faith issue. I've never seen good faith applied to a reasonable suspicion kind of an argument. We're talking about the officer's subjective decisions in stopping this vehicle. That's really not what good faith is about. It's good faith typically applies when officers rely in good faith on legal authority, such as warrants, statutes, or case law. That's not what we're talking about here. And if we apply good faith to these kinds of decisions, there will never be a stop of a vehicle that's concluded to be unlawful. Just completely eviscerate the Fourth Amendment. So we stand on the balance of our arguments, and we very much appreciate your time. Thank you.
Thank you very much, counsel. I appreciate your excellent cogent arguments today. We will take this case under advisement and get you a written opinion as soon as we can.
Judge Walkers, tell everybody hi in Harvey County for me, please.
Will do.
Take care.